Another SAN?
Oh, yeah. My Lord, I'm of the view that it is not mandatory for a defendant to appear. Let's say, for example, now, sir, that there is a plaintiff. He will start his case. Indeed, he doesn't have to be in the witness box. All the witnesses will be cross-examined, including the plaintiff. And all the necessary information can be extracted from the plaintiff and his witnesses. At the end of the day, as a defendant, let's say, for example, the general or the generals involved, I might now say, I close my case, no case submission. You know, that's the point, sir, because all the answers, information that the tribunal might need can be extracted under cross-examination from those witnesses if they are recalled. And then they will say, I'm sorry, sir, we don't have to call my client anymore. That means counsel can address without the presence of the other parties.
That is in a civil case.
My Lord, it's the same procedure, sir.
Hold it. When persons are ad litem, are anybody ad litem here? Is there a list here?
My Lord, virtually there's no list. But my Lord, what I'm saying
is there a list here?
There's none, my Lord.
Yes or no?
I would say yes, my Lord.
Yes. What is the list? Between whom and whom?
My Lord, it's between those who came and gave allegations or made allegations against a particular person. The allegations are the list.
Civil law talks about parties.
Yes, sir.
No section of inquiries, Tribunal Inquiries Act talks about parties.
My Lord, we cannot
witnesses.
My Lord, we cannot run away from it. My Lord, when we have a panel like this, there are bound to be parties. Lord, I'm sorry, sir. Those who came and made allegations.
What do you define parties in law to include?
I'm sorry,
parties.
Sir.
What is the definition of party in law?
Plaintiff, his witnesses.
Is there a plaintiff here?
My Lord, with due respect, sir. My Lord, no, I'm sorry, my Lord, I'm sorry, sir. If anybody enters that box and made allegations against me, as far as I'm concerned, I will call him, well, a complainant. And I become the defendant. While I'm asking him various questions, there may be need for me to say, I do not want to go into the box. I have no case to answer. My Lord, I'm submitting, sir, that the witnesses can be recalled. We can ask more questions, extract past all we need. At the end of the day, sir, my Lord, I'm sorry, sir.
Are we in court here?
My Lord, this is a quasi-court. Quasi-court, sir. You have all the powers of a judge. You can commit people for contempt of court. We are in court, sir. That's my submission, sir. That I maintain, sir, that from the witnesses we can get all we need and say, I won't call my client. No case submission. Yes, sir. I'm sorry, sir.
Can help us if you...
Oh, I'm so sorry, sir. I spoke before my learned senior. I'm sorry, sir.
May it please your Lordship and members of the Tribunal.
Yes, please.
Commission.
This is a very important chapter. Suppose there was no legal man on this side. What do you do?
All right, then. The lawyers are dragging
Go on, please.
I think perhaps there is need here to understand the true nature of the proceedings before your Lordship's Commission. As against judicial proceedings between parties, like in this civil action. Generally speaking, in a civil action, there is a claim, there is a dispute between a plaintiff and a defendant. They are parties who are engaged in adversary litigation. When the plaintiff initiates the action, the summons, the writ of summons, is what is served on the defendant. And the defendant has a choice whether he will respond to it or whether he will not. No one can compel him. No court can compel him. All that the court can do, and will almost certainly do, is to give judgment against him for the claim, and that is the end of the matter. But he may decide that he wants to defend, but he does not himself want to be present at the trial personally. So he instructs his lawyer to appear on his behalf. He files an acknowledgement of service. If he files his defense, on the day of the trial, he does not have to come if he does not want to give evidence, so long as he's represented by counsel. He does not have to give evidence himself in the trial. And the trial can be concluded, his counsel can argue on his behalf, and even eventually, without him coming, win the case if his case is well put. But the plaintiff in that case, however, can still compel him to come to court by issuing a witness summons. Now, I was asking the defendant to come and give evidence on his behalf, on his plaintiff's behalf, if he wants to take the risk. And once he tenders his expenses, the defendant must come. If he does not appear at the trial in answer to that witness summons, the courts can issue a bench warrant to bring him to court. And if he does not give a satisfactory explanation, the court can punish him. Because that summons, that witness summons, is an order from the court for him to appear. He has no choice. And here, he cannot send a message to the court and say, I want my lawyer, this is what I would have wanted to say. Let my lawyer say it. His lawyer cannot say it for him. Nobody else can give evidence for a party.
In respect of a witness summons.
In respect of a witness summons. But the mere fact that he refuses to obey the witness summons to come and give evidence does not disentitle him to pursue his substantive defense of his case. The court can only punish him for refusing to come. His substantive case can be conducted by his client, his counsel. As against that is the proceedings before a tribunal of inquiry. The tribunal inquiry is a totally different institution from its get-up, from its focus, from an ordinary court of law. It has its own terms of reference. And it has its own counsel, which a court never has. And the approach and the procedure is so different. The procedure for the conduct of business, which your lordships have, members of the tribunal have outlined for this tribunal, make this so very clear, the difference so very clear. It is the counsel to the tribunal who will call witnesses. Any witness who comes here will be called by the witness of the tribunal, who will take him or her through the evidence. And all other counsel cross-examine that witness called by the tribunal. So even if that witness is called in support of my own case by the tribunal, I will be cross-examining that witness. So that witness now is in exactly the same position as a witness summoned in ordinary litigation, in adversary litigation. He has an order from the court, from the tribunal, to come and give evidence. And he must answer that summons personally and give evidence and answer questions that are put to him on pain of punishment. And I think the last clause in that Form A makes it quite clear. After setting out what he should do and the documents that he should produce, it says, herein fail at your peril. If he does not come, he runs the risk of punishment. And the form is there. The Tribunals of Inquiry Act provides for the sanction for anyone failing to obey your summons. You're entitled to issue a bench warrant for that person. And he must come and satisfy.
Do you regard Section 5, summons under Section 5, as a writ of summons, as a
it's a witness summons?
Witness summons.
It's an ordinary witness summons. It is not, it's not summons in adversary litigation initiating an action. It's an ordinary witness summons.
The point we'd like you to help us, this point made that under the Constitution, you cannot even issue the summons. What's your reaction there?
Under the
Constitution, we can't even issue this witness summons.
You can't issue a witness summons under the Constitution?
By Mr. Bambo, SAN.
Oh, in respect of a former head of state?
Yes.
Oh. Well, I must say, my lords, I think perhaps the decision given by late revered Justice Obasanjo perhaps is one of the most unfortunate and embarrassing decisions given on the constitutional position in this country. It's most unfortunate, and we all wish that we forget that decision forever, because it is not right and cannot be right. Because the Constitution qualifies it that a head of state is only exempted from court processes during the currency of his term of office. It is very clear.
Mr. Bamba was reading, yes. I drew his attention to A, they said during, yes. B, yes. They said during, C, they kept, yes. Quiet. Yes. So I asked him, what is the interpretative jurisdiction of this, of a court, not here, not a court.
Yes.
If you have a section A, B, C, something is repeated in A and B and omitted in C, how do we interpret it? I wish the Supreme Court would go into that one day.
The interpretation of any section of any law has to be made within the context of the whole document itself. You cannot interpret a section, a subsection of a law in isolation. And it's quite clear that the intention is that the former head of state, the head of state would be exempt during his term of office. The subsection that follows it makes it also quite clear that it provides that the period of limitation, normal period of limitation, will only begin to run against a former head of state on the cessation of his term of office. And I think the prohibition against the issuance of process against the head of state is so clear that the Constitution makes it clear that it is only for that term that the exemption subsists. And that is why that provision is there with regards to the fact that the limitation act does not begin to run until he ceases office. In fact, that is actually saying that after he ceases office, then he is liable to this process.
Becomes an ordinary citizen. After he ceases to be head of state,
yes,
he becomes an ordinary Nigerian.
Ordinary citizen, yes. 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 That is all I propose to practice.
Thank you for the... Another senior advocate who? Let's hear you.
Yes, my Lord. My Lord, I wish to add for purpose of emphasis that the proviso to Section 308 of the 1999 Constitution operates only for the period when the head of state is sitting on the stool.
You are agreeing with your learned?
I agree with him, my Lord. And I must add this, my Lord, that in other jurisdictions, as events have shown of recent, even that immunity is being done away with or is being watered down. And I'm referring to the Bill Clinton experience in the United States. My Lord, notwithstanding that provision, he was taken to court and the matter was entertained. So perhaps we in this country, now that...
Have they got such a provision in their constitution?
I'm not too sure, my Lord, but
how can you compare? They have it.
They have, my Lord, they have. It was waived during Nixon, and during Bill Clinton, the same thing happened. So the bottom line of it, my Lord, is to say that, quite frankly, the provision is to enable the president or the governor perform his constitutional duties uninhibited by court processes and so on and so forth. It certainly will not apply while he has left office.
Next question that will help us. Our terms of reference are very, very wide. Can we ask the functionaries, the executive functionaries, to help us make useful recommendations? Not asking them about the murder or about the detention, just to help us determine what the former heads of state since they were in power then. And one section of our terms of reference talks about atrocities committed during those periods.
Yes, my Lord.
Will they not be very useful witnesses?
In such a situation, my Lord, it's either they come themselves, or if they are aware of relevant departments of government, which will come before you with pertinent evidence. It is my humble view, my Lord, that this commission should rely on such evidence and make your recommendations accordingly.
All right.
That will be all.
If they don't come, we can still make our recommendations.
Yes, my Lord, whichever
if
way.
they don't come.
It will not look neat, my Lord, for us to start issuing bench warrants on our former heads of state. That is my strong opinion, my Lord.
Why? No, please. Why?
My Lord, because of the offices which they occupied. So if...
Oh, no.
I'm coming. I'm entitled to my opinion, my Lord. If by virtue of the offices which they occupied, and the evidence is not
Suppose
personal,
I help you.
And the evidence
Suppose
is not,
I help you.
if the evidence is not personal to them,
I'm going to help you. Consider this situation. We are on a process of reconciling people.
Yes, my Lord.
Would bench warrant aid reconciliation?
I don't think it will assist any reconciliation.
Do you reconcile?
If you compel somebody
to reconcile
here and reconcile under duress, to my mind, my Lord, that is not a reconciliation flowing freely out of the mind of a person who has been brought here forcefully, who has been compelled to appear here.
How do we get them to come voluntarily?
My Lord, if they cannot come, like I've said, you can still make your recommendation.
I see. Thank you.
In the circumstance.
I see. Thank you. Any other essay?
Well, my Lord, I've not replied them yet.
No.
All of them to
when they finish, then we will reply.
I reply.
Oh.
It's okay.
With greatest respect, my Lord, I had occasion to comment that this honorable commission is walking into a new frontier. You are operating under...
Let's get one thing straight first.
Yes, my Lord.
The exemption that will apply to the former heads of state will not apply to your client.
No, my Lord.
I see.
The situation, my Lord, is you have a judicial commission of inquiry set up under that enactment to carry out quasi-judicial responsibilities, carry out investigative responsibilities. At the same time, even though not mentioned, it suggests reconciliation in a psyche and context in which we are all conditioned to being adversarial. In the circumstances, my Lord, you have become what they call, well, you have responsibility without power, the prerogative of the eunuchs throughout the ages. You have the responsibility, the power is not there. So I would call on your Lordship that the first thing you ought to ask yourselves are, what are you here for? And what is the matter before you? What happened over the period between the time the event took place to the time you were seized with it? What are your functions and how do you discharge those functions? My Lord, in the discharge of those functions, unfortunately, we have to get mired into the law. The world can construct the law according to its wits, but you must construe it according to the law. The ground norm is the Constitution of Nigeria. It is downloaded into the normal legislations, and it soft lands into this kind of commission, which is carrying out a function for the first time ever and unknown, into the unknown, to reconcile people, and yet it has no time to even reorient our minds to forget about adversarial system for a while. With that problem, my Lord, the ground norm, if you go to the Constitution, which is the primary law, and repeating section 36 about fair hearing, you would need to relate, my Lord, to what is before you. Like I say, what happened? In the case of my clients, an event took place 15 years ago. Over the years, certain members of certain constituted institutions did certain things, properly, improperly, or otherwise. You will have little choice but to evaluate the historical events that transpired, because you, while occupying a quasi-judicial responsibility, at the same time, you are not duplicating, but being a continuum. So if there was a Nigeria police force which carried out certain investigations, the historical parameters have to be looked at from where you take off in the course of your proceedings and your recommendations, my Lord. And section 36, which requires fair hearing, requires you also to look at the peculiarity of what's before you at the material time. In so doing, for example, we have an application which was subsumed by my learned senior as to the request that you dispense with the need for his client to appear before this honorable court. That was based on antecedents before this commission was set up, the actions taken by a constituted authority by certain persons alive and records which are there, and thereafter, after you came into being, the events that took place in the last 1 year, let's say from December to now, would have to be taken into account to determine whether a particular, the exercise of your discretion, which should be judicially and judiciously exercised, should be so done in the context of the particular person. For example, I would not like to take my learned senior for the 30th arrest for contempt. The learned reverend gentleman advised against it. It has happened. So there is a little bending backwards. In the circumstance, there is a little that one can do, but to look at the circumstances as to why you should dispense with certain appearances. In a normal court of law, you have options, my Lord. Interrogatories.
Suppose we put it this way. Have you got the Constitution?
I have, my Lord.
Read section 36.
My Lord, section 36, subsection 1. It's already been read by the other. In the determination of his civil rights and obligations.
In the determination of his
civil rights and obligations.
Huh?
Yes, my Lord. Including any question or determination by or against any government or authority. A person shall be entitled to a fair hearing within a reasonable time.
Stop.
Yes, sir.
Where does this apply?
Now,
In the determination of the civil rights and obligations, when there's an infringement of your right, you sue.
that is the new frontier, my lord, because you are going
Am I
to make
right?
certain recommendations. Sorry.
No,
okay,
you may
sorry,
have
my lord.
exceptions, but am I right that when there is an infringement of your right, you have a lease
Yes,
to
my
sue,
lord. Yes, my lord.
and you have parties
Yes, my
ad
lord.
litem?
Yes, my lord.
Is that the same thing here?
That is why I say you are in a new frontier halfway, sir.
I see.
In this context, a person called here with certain insinuations of one way or the other, which are accusative.
So
and with the whole-
you agree that ideally this will apply to adversary proceedings,
adversary procedures.
but not solely, mainly, but not solely.
But you will be mindful of it in this case, my lord. You will be mindful of the fact of taking account of that provision, because a witness that's called here with certain grave insinuations is a little above a witness, because he is facing social conviction nationally, internationally, and within this hall. And he may be perpetually convicted socially, which is worse
Next
than
thing I'd like you to
judicial.
help us.
Yes, my lord.
Witnesses have rights.
I'm sorry, my lord.
Witnesses have rights.
Which?
Witnesses have rights. Yes. Parties also have rights.
Yes, my lord.
Are they the same?
In this case,
The rights of parties and the rights of witnesses, are they the same?
they are similar in your case, sir.
I see.
They are very similar because in the process of our experience in the last 1 year, your lordship was compelled to have to say nobody is being accused, nobody is under trial, but we would not heed. In that case, the level of a given witness in his circumstances indicates that he is just more than a witness if there are allegations against him. But if he was just called, please tell us.
Next area I want you to help us is many, if not all the cases cited deal
Yes, my
with
lord.
actions in civil proceedings.
Yes,
I
my
don't
lord.
think any dealt with tribunal. So we've got to be a bit careful
Yes, my lord.
using them.
Indeed, my lord, we have to be careful in that, to a certain extent, my lord, because
If you
this-
agree
this-
with me there,
to-
we'll use them,
Yes,
but
my
we have to
lord.
be careful.
yes, my lord, to a certain extent, in the sense that this judicial commission of investigation, the operative word is judicial, and therefore it was nascent and grew out and sprouted from the culture
Next
of
thing
the
I'd like you to
judiciary.
help us.
Yes,
Look at
my lord.
Section 18 of the Act.
Yes, my lord, the witnesses.
Any person,
Representation.
any person whose conduct or affairs are the subject of inquiry under this Act, that
Yes,
will
my lord.
relate to people who have petitioned.
Yes,
But
my
it
lord.
goes further than that. Or who is in any way implicated or concerned in the matter under inquiry. Leave the word implicated.
Yes, my lord.
Take the word concerned. Do you agree with me that all the heads of states are persons concerned with things in our terms of reference?
My lord, all the heads of states are concerned at certain levels of responsibility.
Good.
If the director of forestry in Jos went about cutting all the trees in Jos, and the head of state is here,
Now that you mentioned that,
the level is
our
not his
term of
own.
reference said, let them tell us whether this deliberate state policy or policy of any arm of government, or whether it was abused by state officials.
Yes, my lord.
So that is,
So in the circumstance, in that case, my lord, the head of state's concern will be part of your discretion to say, in these wide terms of reference,
Yes.
should we call A, B, C, D and say he is concerned simply because he read a thing on the newspaper during his dream under him?
That's why I said they put the word implicated. That will some tint of liability or
Yes,
responsibility.
sir.
Just concerned, a person who has something to say about what happened.
My advice therefore, my Lord, is for your Lordship and honorable members to consider the various options which normally obtain in court of law. Should we send interrogatories in respect of A, because there are serious peculiarities in which his image, prestige or security may be affected, or he is irrelevant? Or should we go to him and see him, or should we write him or invite him, depending on the nature of the matter and the relevance, and whether an interrogatory would suffice?
Have we got our terms of reference?
Yes, my Lord, I have got it.
If you look at D,
My Lord,
yes.
I recommend measures which may be taken, whether judicial, which may end up in prosecution.
we were talking about not anybody accusing him of anything.
Yes, okay,
Coming
my
to
Lord.
let us know what measures we may take.
Yes, sir. Recommend measures, whether judicial, administrative, legislative, or institutional, to redress the injustices of the past and prevent or forestall future violations or abuses of human rights.
Can they help us there?
They can in general terms,
They can.
in which case, my Lord, they are not compulsible witnesses. They would be voluntary witnesses for that purpose. You are inviting them as good citizens to please be such good citizens in helping you constructively
Yes.
move onwards for the sake of the nation, just like you are inviting us here.
Yes.
It's exactly the same situation.
All right, what about C?
See, my Lord,
Yes.
determining whether such abuses or violations were the product of state policy or the policy of any of its organs or institutions, whether they arose from abuses by state officials of their office, or whether they were acts of any political organization, liberation movements, I think that was called out of South Africa,
Accusations aside,
or other groups.
just leave accusations that
Yes,
they
my
did
Lord.
this or did that.
In this case, my Lord, you would call for that based on your own internal study of the history of the facts and who handled what, who did what.
Can we call them?
If at the end of your deliberations you
We have deliberated,
haven't deliberated, then
and then we set summons after our deliberation.
you may issue summons, but you will have to operate the summons within the ambits of the law.
So you are asking us to
Within the law, my
hold
Lord.
it. I agree
Yes,
with
my-
you
yes, my
that the general summonses issued were restricted to abuses by victims. We should issue a better summons.
No, sir. My Lord, you should issue summons within the law. If my Lord, if I refer my Lord to section
Sorry,
6,
Counsel.
I'm sorry.
Just one moment, because I'm
Yes.
in sympathy with what you're saying.
Yes.
I think that what is clear is that the fear of the witness box is the beginning of wisdom.
The
Now,
beginning of wisdom.
perhaps we can
Yes.
call it something else other than a witness box. And we can, rather than use the word summon, we can talk about a letter. Because I understand, from the point of view of what you are saying, and what,
Yes, sir.
what the chairman is saying,
Yes, sir.
I'm in sympathy with your position in the sense that if, and what the chairman read when we began the final phase of this sitting, I think it was section 3,
Yes.
made the reference to the fact that if a witness appeared,
Yes, sir.
the cross-examination or whatever is going to go on will have to be restricted to the subject of the petition.
The subject of the petition.
Of the
yes,
petition,
sir.
yes.
Which?
And yes, so that if once you dispose of the issues
Yes, sir.
from that petition,
Yes, sir.
it will be considered that that case is closed. Now, it seems to me that as long as somebody remains in that witness box,
Yes, sir.
if you then ask him whether he has any recommendations to make
Yes,
about
sir.
what should be done, the fear is that that evidence could be used against him. In which case...
It may be, yes.
Yes, in which case the Commission has... We've actually gone to great lengths to source for this kind of information,
Exactly,
which ties up with what I think Mr. Akwabo was saying.
Exactly,
that there are other ways. But my own feeling is that this is why I keep saying that for me, a lot of the issues are not about law. Even if these people came here and tried to explain to us the issues you are explaining, namely, in governance, this is not how, it is not that one person just wakes up and does this, that, or the other.
Yes.
Even if you appeared to say these kind of things, or to say what you can answer and what you cannot answer, what immunities and what limitations you have.
Yes.
I think these are these are some of the issues, and that is why even when you say that it is not adversarial, we are literally in a trap. But the point still remains that the issues we're talking about are merely, as I said, I don't know, I don't want to emphasize the legal. It's just to say that there is something symbolic in the issues that we are discussing. That even if the people came here and simply said to us, yes, this I can explain, this I cannot explain, this I want to answer, this I don't want to answer. Those are the kind of issues that we're talking
yes,
about.
my lord. These are issues that can be very pertinent, I agree, my lord, in that kind of class of matters. But in matters where the witness is concerned for certain very severe insinuations and the environment creates a problem, you need to consider that in considering that his coming would be unfair, and therefore call on you to exercise your discretion subject to necessary exceptions, which means your judicious and judicial consideration of exceptions will include the fact that we are inviting this head of state, but we said in respect of A, B, C, D said against you, and the events of the past 12 months have not quietened his anxiety. Therefore, you should consider other alternatives for the purpose of calling them. My lord, I was going to go into the issue of the witnesses actually to limit myself to the area, having put these preliminaries, because I want to go to the issue of what constitutes the appearance, my lord, the initial questions.
I think we have got enough submission and appearance.
Yes, my lord, but I have...
In the civil courts and in tribunals.
Yes, my lord, but...
The appearance by counsel, we've got enough.
But there's a general, position. In law, a party can appear in person or by his counsel on his behalf.
A party?
Yes, in which case a person may be relatively a party depending on what he was addressed with in the summons, and the legal effect will be as if the party himself appeared in the absence of overriding legal position. Your Lordship in Adegoke Motors and Desanya actually went to Jewish dictionary and said, as Desanya 1989 3 NWLR part 109 at page 272, in the primary sense of the word, the parties to a proceeding...
19 what?
Adegoke Motors Limited versus Adesanya, 1989, 3
9
NWLR, part 109. Yeah, maybe don't.
Yes. What did he say?
Well, Oputa JSC, quoting Jewish Dictionary of Law 59 at page 132, said, in the primary sense of the word, the parties to a proceeding or application. This time, my lord, I want you also to discountenance my using parties by considering my witness as a bit higher.
Are you reading yourself? Read.
The parties to a proceeding or application are said to appear on it when they are present in court, when it is heard. A party appears either in person or by his counsel or his solicitor. And in another authority, there was a statement that a plaintiff not present in court but is represented is as good as being present. Now, the other issue, my lord, which you asked, if it's been answered, is then I will skip it. Is an appearance by counsel sufficient enough to constitute an appearance?
In a civil case.
Yes, my lord.
Not in a tribunal.
Not in a tribunal, but a judicial tribunal which is investigative, which is accusative mentality. One has to be cautious about those, my lord. But of course, in civil case. Wherefore said, it follows in my view that the third plaintiff is represented by a legal practitioner. It is as good as personal appearance, and the legal practitioners could be properly served with the pleading and other documents. Of course, I am warning myself that I am talking of a party in a civil court, but I am also advising myself that the mentality here is
Chief Ajay has drawn a difference between ordinary civil proceedings and tribunals. Do you agree with him?
Judicial tribunals.
Yes. Do you agree with him?
In part, my lord.
You do?
There are differences in part.
Oh, I see.
And there are similarities in part.
Do you agree with Chief Ajay, his submission?
I
do not draw a distinction between parties to a civil case and witnesses in a commission of inquiry. Well,
no,
we have it down.
My lord, that has been answered, but there is little. The difference depends on the personality and the issue and the circumstance. The issue now of can a client cross-examine a witness when his client has not appeared? Now that, my lord, does not apply to my clients in that they have responded and they have filed an application as to the need to dispense with appearance of at least one of them. If I can go to section 192 of the Evidence Act, my lord, unfortunately this is not the right place to canvass law totally. Any person, whether a party or not, that's Evidence Act. Section 192. Any party, any person, whether a party or not, in a cause may be summoned to produce a document without being summoned to give evidence. And if he causes such document to be produced in court, that court may dispense with his personal attendance. If a party, therefore, produces documents which are sufficient after you have exercised the discretion that you could call for it, since you cannot guarantee one or two things, especially, my lord, sometimes...
Aren't you putting the cart before the horse?
My lord.
One, can a stranger to proceedings introduce documents? A complete stranger?
He may apply for your leave to introduce documents.
He can, I cannot. Can a complete stranger to proceedings introduce?
He may.
He may.
Not can. Right. He may if it is material relevant.
When do you become party to a proceeding?
When you are either a party ab initio or when you apply and you show that you have an interest.
When do you become party in quote to tribunal proceedings?
When
I'm using party in quotes.
When you
they are not parties, they are witnesses.
When you are informed, come, your regime is accused of murder, therefore come and answer. Then it becomes relative. Everything, my lord, is relative. You are in a very terrible situation of waving through the forest to find your way.
Last question.
Yes, my lord.
Chief Apangwa did mention that a case is pending, and this commission should have not been holding, although there's no order. Are you not in contempt by appearing?
My lord, I am...
Two of you?
No, my lord, in the...
You also in contempt.
In fact, I had to...
If the commission is in contempt and you're in contempt, where would you go from there?
So my lord, that I had
all in contempt.
Yes, but I had, excluding the tribunal.
Both the bench and the bar.
Excluding yourselves, my lord. I had to advise myself that I looked at the order of the Federal High Court. I found you were stopped from inviting...
I asked this question.
Yes, sir, madam.
It shows we don't get much by empty legalism in an occasion like this. We have to do more than sticking to our guns if we really want to save this country.
Absolutely, my lord. I fully agree with that.
It's a beautiful legal, tussle legal exercise. I enjoy it as a lawyer, but as a Nigerian, I'm not enjoying it.
My lord, Mungo Park did not enjoy coming to Yauri and getting hit at the rocks. It's very tough getting into new frontiers.
Any other lawyer, we've got your submissions.
Okay,
yes.
my lord.
Where is Belafado? No. Let's hear them. This is the only.
With the greatest respect,
Yes. You want to speak as well? What makes you say?
Yes, it doesn't matter.
Yes, my lord, may we make a submission now?
No, who is?
I'm sorry. Let me just.
Whom are you appearing for?
Reapo and Newswatch.
What are you submitting?
We are one of the petitioners.
Where they ask?
My own submission is very, very short. Just to agree with Chief Ganifaimi and Chief G.O.K. Ajayi that
counsel appear for an absent client in a tribunal of inquiry.
Appear for an absent client? It's not possible.
It's not possible.
What we are saying is that
no. Issues before us.
Yes.
If he hasn't appeared, can his counsel appearing by proxy cross-examine witnesses?
No.
No. So you agree with Chief Ganifaimi?
Oh, yes.
All right,
definitely.
then. Any other thing to...
No, I just want to add that once the witness summons have been issued and served, the person served that fails to come to the commission the commission may commit the person for contempt.
No, we can't convict. We may recommend him for summary trial.
Commit for contempt.
We don't convict.
That is what the law says.
Commit.
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 For contempt, because that is what the law says. Once the witness summons has been issued...
Read that, read that again.
Yeah.
Section what?
Yeah. My lord, Section 10.
Yes.
Any person who, after serving service on him of a summons to attend as a witness or to produce a book, document, or any other thing, and notwithstanding any duty of secrecy, however imposed, fails or refuses or neglects to do so, or to answer any question put to him by or with the concurrence of the tribunal, shall be guilty of an offense and liable on summary conviction to a fine of 200 naira or to imprisonment for a term of 6 months. That is what the section says.
Summary trial by whom?
On summary conviction to a fine.
Who will convict? This tribunal?
My lord, this tribunal can convict him from contempt. Yes,
I see.
Yes, my lord. If they fail to appear...
It's your submission. We noted it.
I'm most obliged.
I see.
They must be compelled to appear.
And then if
I'm most obliged.
Summary conviction. Any other before we... Yes, sir. All right. My lord, 3 questions. What constitutes appearance? Can counsel appear, or can a party appear by proxy in, not in a legal tussle in the High Court,
my lord,
but in a tribunal inquiry?
My lord, you have a problem of interpretation of the Act itself.
Which Act?
The Tribunal of Inquiry Act, sir.
We've been interpreting it all the morning from 10 o'clock.
Yes, that is where the problem is.
That is number section 5, section 10, section
5C,
12.
If you read 5C,
yes,
there's an exception there. If you read section 5C, it means it is not mandatory for all witnesses to appear.
We had that 4 times.
Now,
it's not new.
If you read it in conjunction with 18, then your problem will be solved. And then on general questions, you are tasked.
What is the result of reading it with 18?
It means that
you may be represented by counsel.
Yes, my lord.
What does that mean?
What it means...
Having, even in the normal court, you appear first.
My lord, you said you are not a normal court.
Yes. All right.
You have distinguished between a writ of summons in an ordinary court. All the cases have been cited to you have not distinguished between a commission of inquiry and a civil court. They are not all false. There should be distinction.
What is the connection between 10 and 18?
10 and 18. 10 says you can punish if somebody doesn't come. But if you follow the exception in 5C that says subject to all just exception, if the person can justify he's not coming here, then he falls within that just exception.
When is that justification? He will stay in his house and justify.
No. His counsel can argue that a case, my lord.
I see.
Yes.
One justification this morning is that the Constitution.
Well, that is one example.
This morning.
The former head of state. Yes, those are the examples.
When in office or
I can also
after
say
3 generations.
I can say that the director of state security services can provide answers for you. That is another just justification. I can also
Any
say.
other thing?
Thank you, my lord.
Any other thing?
Yes, my lord.
Somebody is standing. I'd like to give the bar full facility. No. Chief, hold the moral armor. Keep your powder dry. Yes? Let this. How they come tomorrow? This is a very.
My lord, I'm a Jan. My lord, the purpose of a
Number
subpoena.
one, can a party appear by proxy?
Yes.
Can a party in quote?
My lord.
Can a party appear by proxy?
Yes and no, my lord.
All right.
Yes.
We have written yes and no.
My
If he
lord,
appears by proxy, can he cross-examine? Yes and no too.
No, my lord. My lord, the purpose of your subpoena is to get evidence, even though this commission is not a court of law. But, my lord, in between, this commission has a duty not to endanger national security in the process of taking its evidence.
Are we taking evidence from people who are not even here?
My lord, I'm coming to that.
All right, since you're talking about that, you haven't read our mandate, you haven't read the law.
No, within the issue.
Have you read the law? Have you?
That is why I'm standing up, my lord.
Have you read the law?
Very well, my lord. And I also know the issues that are being framed by your lordship for address. And your lordship wants assistance from counsel, and I'm prepared to offer one.
Have you read the law? I ask you. Open the law then. Section 10.
My lord, I don't.
Open the act. Section 10. And read it. Any person who, after service on him of a summons to attend as a witness or produce a book or any other thing, and notwithstanding any duty of secrecy, however imposed, what are you talking about? No matter what amount of secrecy,
if my lord is
obliged to come. If
my lord is patient with me as my lord has been with the senior advocates.
Look, we've heard about advocates. Yes. If you don't agree with them, write an opinion and give us. We'll look at it.
My lord, I won't be more than 2 minutes if my lord will be patient. I won't be more than 2 minutes. My lord,
go on now, say what you want to say.
My lord, the 3 key witnesses that are being subpoenaed and who are not before the commission.
The question before the court is, number one, can counsel appear for an absent witness?
He can, my lord.
2,
yes.
If he does not appear, can counsel cross-examine?
He can, my lord.
Thank you very much.
Is my lord interested in being guided?
That's all we want, and you've answered the question.
Thank you.
No. What
my lord,
I've had senior advocates. You are not one yet. Let's. Yes. Last. We have other cases on the list. Yes, what is your submission?
My lord.
Are you one of us? Well, sit down. Now somebody standing. Yes?
My lord, our...
Question. Can counsel appear by proxy for an absent witness?
The answer is no, my lord.
No.
Yes, my lord.
If the witness summoned under Section 5C does not appear, Can counsel appearing for him cross-examine?
The answer is a resounding no, my lord.
The answer is no. Thank you.
Yes, my lord.
Now, do you want anything? I want reply to only one point. The point that the Constitution has a provision that we can't even issue the summons. Only on that point, and no other point.
Well, my lord, I agree with the lordship, sir, but I must clear a personal issue. My learned friend has talked of contempt.
No, don't worry.
No, my lord, it's very necessary, sir, because we are also talking to the world. I have not committed any contempt because, my lord, this document...
I'm only interested in...
Yes, sir. Yes, sir. This document is Exhibit 3. It's Exhibit 3. So it is not contempt to exhibit an exhibit.
All right. Noted.
Secondly, this book, my lord, is also Exhibit 2. And it shows how Brigadier was bombed to death. And therefore, this document, which is also an exhibit,
that will be addressed.
So, my lord, it's not right for my learned friend to say I've committed contempt by exhibiting what is an exhibit. Now, my lord, the other issue I want to mention, he has said that Babangida was not directly mentioned. My lord, if it looks at our petition, which I have here, your lordship will look at paragraphs of the petition. That is Exhibit 1. My lord, Exhibit 1 is so clear, and my learned friend unfortunately has not read it, with all respect to him. If you look at paragraph of that exhibit, which can be shown to my lord, paragraph 6. Paragraph 6 states clearly names and addresses of persons who are directly involved. General Ibrahim Badamasi Babangida, President of the Federal Republic of Nigeria. Then, my lord, if you look at paragraph I, that is 7I, it speaks of the evidence that will be adduced to show that Gloria Akon was a courier for the wife of Mrs. Babangida. So, no, please.
I'm only interested in one point.
Excuse me. No, my lord, I'm sorry, sir.
Chief Ganefayemi, I'm interested in, two of you can go on standing. It's all right. Don't worry.
My lord, he is repeating the libel, and that is why it may not be fair to call these people to be handled the way they are. I'm sorry for having to interrupt, but
I've asked you
finally,
to address,
sir, on this point.
Hold it. If the court tells you that you address on one point, it means they're satisfied on other points.
Much obliged.
Well, then address us on this question of we cannot even issue this summons.
Much obliged, sir.
That's a very radical one.
I have already advised your lordship, sir, but I will say, sir, relief sought to recommend for the prosecution of General Ibrahim Babangida for murder. So how else do we involve him? He is already involved.
Asking about his submission.
My lord, his submission now on the constitutionality.
Yes, that's all.
It's unfortunate that my learned friend is not aware of the case of Ganefayemi versus Inspector General of Police against Tinubu, reported in year 2000, 7 Nigerian Weekly Law Report, part 665, at page 481. I repeat, Fayemi versus Inspector General of Police in re Tinubu's falsification, forgery. That's the governor of Lagos State. Number 7 Nigerian Weekly Law Report, part 665, page 481, where the Court of Appeal held that police, which is inferior to this tribunal, can investigate allegations of crimes committed by Mr. President, while in office, Vice President, while in office, Governor, while in office, Deputy Governor, while in office. If they can be investigated while in office, how can the fighting tribunal?
I don't have a copy because we haven't got the library here.
Yes, I'll make a copy available.
If you can give us all the things quoted.
I will make 7 copies available.
Thank you. That's all we want.
So, my Lord, how can ex-president not be investigated? How can he not be
You have
accountable for
made your
investigation?
point. You have made your point.
Now, furthermore, my Lord.
Yes. How many days, well, when we read this ruling?
Much of pleasure.
Today is what?
So, my Lord,
Monday.
it was easy to kill, but it's not easy
When
to
do we
account.
come for ruling? When do we come? No, we have another case tomorrow, is it? Counsel for the... I want all the cases involving these ex-heads of state addressed before we write a composite ruling. Is there anyone? We have done Abdul Salam, we've done General Babangida. Another case is
Abiola's case tomorrow.
now. Who is there?
It's
General
Abdusalami Abubakar.
General.
Well, Abdusalami Abubakar, my Lord. General
No.
Abdusalami.
What about the general who wrote us is traveling? He's coming back.
That's Buhari, General Buhari. He appears in Umaru Diko, Lele Gabare, and Owo.
Buhari. What about Buhari?
Buhari, my Lord, yes.
His counsel is here.
He wrote to say he was traveling.
Buhari counsel. When is this case coming up?
Owo.
Because
on Wednesday, my Lord.
we need to hear all so that we write one composite ruling.
Yes, my Lord.
After hearing Buhari on Wednesday, then we can give ruling maybe Monday after Wednesday is what date?
My Lord, Monday is 1st October. It's a public holiday.
4th October?
Yes, my first. Independence
3rd
Day.
October. Oh, 1st?
Independence Day, yes, my Lord.
Can we sit on the 1st?
No, my
Answer
Lord.
is no.
No.
So 2nd then? Why?
The 3rd, my Lord.
For ruling?
Yes. Yeah, the 3rd is more convenient, my Lord.
2nd October then, ruling.
My Lord, being a national day, I think we should...
my Lord, I'm
People
sorry.
want to celebrate.
Yes, no, we
All
should.
right.
It's
At
a
least
day of national loyalty. Not
All
to the
right.
government, not to this government that doesn't care for the people, but for
no.
for our nation.
Nobody's asking about that.
My Lord, I'm sorry, my Lord. My Lord.
3rd.
The 2nd is a
Third.
special hearing day.
3rd. Well, ruling adjourned to the 3rd.